We're going to take let's take 5 minutes so that we can clear the room and just stretch our legs. 5 minutes. We'll be back at 5 minutes after 4. His bill. We've got a few more bills. Hopefully it will not take quite as long to be heard. Our first item, we are hearing items in file order. Senator Liu will be up next. So if her staff is listening, we've got Senator Lara's SB 14 and then Senator Liu's SB 68. We've got part of our group here, but we'll let you get started. Senator Lara, SB 14, please proceed so that we're clear. We're going to have go back to the regular rules of the game, our standard practice of our committee to allow each bill to have 2 main witnesses, 2 minutes each for support, and similarly 2 main witnesses, 2 minutes each for opposition. So, Senator Lara, please proceed.
Thank you, Madam Chair, members. Before I begin, I just want to thank your staff, Ronak, for all her help on this issue. It's been a couple months, and I appreciate the staff time from your committee. I would like to accept the amendments on page 8 as author's amendments. SB 14 will increase protections for child victims of sexual abuse in civil courts by preventing an adult in a position of authority, like a teacher who sexually abuses a child, from claiming the child consented as a defense. Additionally, the bill will ensure a victim of child abuse, their sexual history cannot be used as evidence against them. California criminal law places higher penalties on those in position of power over a minor, such as a teacher, coach, parent, or anybody who sexually abuses a child. Despite the consequences, according to the 2014 federal GAO report, child abuse in public schools, nearly 1 in 10 students are subjugated to sexual abuse by teachers, coaches, or other school personnel during their K-12 career. Some of these victims later sue their assailants or responsible third parties in civil court, seeking to recover damages for the trauma they suffered. Currently, in California, different rules apply to sexual abuse cases depending on whether the case is in civil or criminal court. Shockingly, in civil cases, a perpetrator can argue that the child consented to a sexual relationship with an adult in a position of authority, and evidence of a child's sexual history can be introduced as evidence against them. Recently, a teacher in my district was convicted in criminal court of lewd acts against a 14-year-old student and was sentenced to serve time in prison. Following that conviction, the victim's family filed against LAUSD, alleging the district had been negligent and the victim had suffered serious emotional damage as a result. LAUSD members successfully argued in court that the 14-year-old student had consented to have sex with her teacher and was permitted to use her sexual history as evidence in their defense. This is not only immoral, it's disgusting and violates the victim's rights. This is not an isolated incident. Other school districts around the state and employers have made similar arguments in civil cases. These differences between civil and penal code are dangerous and threaten to allow sexual predators and indifferent entities off the hook from child abuse and negligence. SB 14 will close these loopholes and ensure that the victims' rights are protected. I respectfully ask for your aye vote.
Thank you. Senator Lara, witnesses in support?
Christina Romero, Planned Parenthood Affiliates of California, representing over 115 health centers in the state. I just want to thank the author for his work on the bill. We came to him with concerns, and he alleviated those with the help of the Senate Judiciary Committee. I've got Beth Parker here to answer technical questions on the bill.
Madam Chair, and I also just want to say that one of our other star witnesses had to leave because of time, so apologize for that.
All right. Well, sorry that we went so long, but we have another witness here.
Staff.
Staff. All right. to answer technical questions, or do you want to?
No, I'm just chief legal counsel, and I worked on the amendments, and I'm happy to answer any questions about them.
All right, thank you. Senator Hertzberg?
Yeah, I just want to try to understand, certainly the notion of a defense when you've got a 14-year-old kid's inappropriate, but what worries me a little bit about this, as we balance out the public policy of all the things we've got to balance out, do we have, let's assume this happens at LAUSD, right, and this is a horrible act. Is the school district now liable for this because there's no defense? I mean, what's the school district trying to do is to protect the treasury. Lawyers have to act tough to defend their clients. So now we say there's no consent, which is fine. I'm okay with that. I agree with that premise. What worries me is that we're going to find ourselves in a situation where the school districts are going to spend $500 million a year in these cases. Can we limit liability to the teacher or create a different standard where we get into the treasury? We've already got a big problem as it is trying to pay for government and people complain about taxes. And you end up, you want to stop the behavior, you want to punish the person who engaged in the bad act, but you want to create this situation. It's one thing if it's a private company and you nail those guys. It's another thing that there's a competing governmental interest because we're taking $500 million out of the treasury of schools, right? Because we have a bunch of bad actors like what happened with the church, right? I just wanted to know if you've given that any thought. That's one of the concerns. I'm sorry, sir. Yeah.
If I can respond.
Please do.
Thank you, Senator Hertzberg. The bill does not stop a district from defending itself. It doesn't prohibit using, it does, although prohibit the use of the child's sexual history as evidence, except for this, very narrow exemptions when appropriate, and that's what we're trying to get at only.
Yeah, I guess what I'm trying to get to, I completely agree. I don't like all that history stuff. I think when someone's 14 years old, you're 100% right. What I'm worried about is the lottery aspect of you have some bad actors. Look what happened to the church and what its impact was. Okay, they did bad stuff, but what is the impact? What's going to happen? Are we going to end up creating a ton of lawsuits where somebody gets these huge judgments, and then all of a sudden we can't pay for all this education stuff? These are competing public policy interests. How do you balance those? I'm interested in the jackpot judgments, right? I want to nail the teacher for doing the bad act. I want to hit them hard and have the impact on them. But the judgment, the size of the judgments, it worries me that if you eliminate defenses, what you do, at least as I think about this, is that you end up having a situation where the school district's going to pay all these big money. And I don't know the answer to that. Those are hard questions.
So,
Can I jump in for a second? First, the situation with the church was, I think, different because the church had knowledge of what was going on. And I think in some instances where the school doesn't have knowledge or reasonably shouldn't have had, wasn't likely to have knowledge, that is a defense. And right now, right now, the schools have some level of liability anyway. So we're not necessarily opening a Pandora's box here. This is just a situation where there is an offense, a sexual assault, or I guess to sex with an underage student, and that this will, that has always, I guess, been unlawful. It's just that this clarifies the law, and it, I think, also still protects the school and school district if there was no reason for them to have known.
Correct.
So again, if the school does have knowledge, part of the reason for the lawsuits is so that there's some level of liability for not doing what they should have done. But to the extent they don't have knowledge, I don't think that this imputes knowledge to them. I don't think it changes that part of the standard. I could be wrong, but that's...
Sorry, Madam Chairman. LAUSD already had gotten several reports over the career of this individual, and nothing was done. And so that gave the ground for the family to then sue the school district.
Senator Leno.
Thank you, Madam Chair. Just with regard to Senator Hertzberg's concern or question, I think what this will do is send a message to school districts. Watch out. If it starts from the top. You've got to communicate to everyone who has authority over the student body that this will no longer be the way they can defend themselves.
Right.
And there will be liability, and you want to prevent the cost to the district. and you want to prevent the act from happening in the first place. And I think that's what Senator Lara is trying to get at here. And it is specific and narrow to a situation, not of all statutory rape, but when there is an authority, person employed as authority is engaging with a minor. And these are fuzzy lines, right? We talk about what about the 18-year-old boyfriend, the 17-year-old girlfriend? It's illegal, but these are different situations. And this is a domineering situation because this person has authority over a student.
And if there are questions about cost, this will be going to appropriations so that that can be hashed out there.
He's the appropriations chair.
Look at that smile.
I'm glad you recognize that,
Technicality
Senator.
after another.
Oh, wait, it's not.
I'm sorry, is it non-fiscal? It's non-fiscal? All right, I apologize, it's non-fiscal, so it doesn't even have to go back to him. But that is the issue, is it's a position of authority, and if they should have known and did not take appropriate steps. So, and with 10% of this kind, apparently estimating 10% of students experience this kind of situation in their school career, I think we got to do something about that. That's to protect our kids. So I hope it's a wake-up call, if nothing else, for that kind of behavior. Yes, Senator Anderson.
Madam Chair, the numbers are staggering. It's alarming. And I believe that part of the issue is many of the school board trustees aren't taking their job as seriously as they should, and that they're not including how to address these issues with the collective bargaining and the rest. The fact that someone can retain their job while going through this after being found guilty is absolutely outrageous. And so I want to commend the author, and I'm a proud co-author of this bill because I think it's an outstanding first step to address, as you described, a pitiful situation that we're allowing these predators to take advantage of our children. It's wrong. Thank you.
Okay, opposition, is there any, or I should say any public members who wish to speak in support of the bill? Is there any opposition to this bill? All right, and questions have been asked. Any further questions from the members? Moved, motion by Senator Leno. As amended, motion do pass
As amended.
to
The floor.
the floor as amended. Do you wish to make a closing statement?
Thank you, Madam Chair. I respectfully ask for your vote.
Very good. Madam Secretary, please call the roll.
The motion is due pass as amended to the Senate floor. Jackson?
Aye.
Jackson, aye. Vidak? Aye. Vidak, aye. Anderson? Aye. Anderson, aye. Hertzberg? Hertzberg, aye. Leno? Leno, aye. Monning? Aye. Monning, aye. Wachowski?
All right, that bill has enough votes. We will leave it on call for the absent members. Thank you, Senator Lara, and thank you, witnesses, for your testimony. All right, moving right along here, speeding along. We have item number 2, SB 68 by Senator Liu, Minor Parents and Reunification Services. Good afternoon, Senator Liu.
Good afternoon, Madam Chair, members. This bill will help, or SB 68 will help reunite teen parents with their children, keep families together, and reduce costs to the state. I want to thank the committee staff for working with my office and the bill's sponsor to craft the amended legislation before you today. The juvenile court judges of California yesterday delivered a letter requesting 2 more changes to the bill, and I am committed to working with the judges on these issues, which appear technical and can be resolved as the bill moves forward. This bill simply extends for 6 months reunification services for minor parents who are making significant progress in a court-ordered reunification plan. The bill also recognizes the unique challenges faced by teenage parents. Children of minor parents are at greater risk of permanently losing their families because of barriers that impede reunification. This bill requires the courts to recognize these barriers, protect these families, and enhance the reunification process for children and their minor parents, giving them their greatest opportunity to succeed. For example, minor parents might be enrolled in school or pursuing other educational opportunities. This limits their chances to effectively utilize parenting skills enhancement programs within the time frame normally allotted by statute. Minor parents also face substantial legal barriers that prevent access to full-time employment appropriate childcare, transportation, and housing. Studies show that returning children to their families rather than keeping them in foster care saves the state and county money. It is estimated the cost to maintain a child in foster care with all the ancillary services is approximately $44,000 a year. The bill is sponsored by the LA Dependency Lawyers, a nonprofit group that represents parents in the dependency court system. I have a witness that can answer technical questions. There's no opposition, and I ask for your support on the bill.
Thank you, Senator Liu. Witnesses in support?
Sure. My name is Robert Stevenson, and I'm the Director of Policy for the Los Angeles Dependency Court Lawyers, the sponsor to this bill. I've had about 40 years' experience in the juvenile dependency system. I was a bench officer for 8 years. I heard thousands of these cases. Again, just agreeing with the author, of course, Senator Liu, this bill is very important for teen parents for the reasons she stated, but also because we have to remember teen parents, but not only teen parents and the barriers that they have with respect to reunification services. These are adolescents, and if we've raised teenagers before, we know what adolescents are going through. The changes emotionally, cognitively, physically, they're challenging. And these young people who are in foster care, they were victims also of abuse and neglect. So they have those issues still in them, scarred because of those issues. So they're dealing with that. They're dealing with being a foster parent. They're dealing with adolescence. They're dealing with barriers, real barriers to getting into reunification services. So I would urge the committee to to continue considering this bill. And I would be happy, our organization would be happy to work with the author on any proposed amendments. I just received this proposed amendment today from the Juvenile Court Judges of California, so we will need time to talk with the author about these technical issues.
Thank you very much. Any other witnesses in support?
Rebecca Gonzalez, National Association of Social Workers, California chapter in support.
Thank you. Anyone here in opposition? Is there any opposition? Yes, come on up.
Alan Hertzfeld, Judicial Council. We don't have an opposed position on the bill, but we do have some technical concerns, probably similar to those of the juvenile court judges, and look forward to working with the author and sponsors.
Thank you. Is the author aware of your objections? Have they been presented?
I am working on the amendments that we will be bringing to them. I'm sorry I haven't been in touch to this point.
Okay. Well, let's hope that I know that the senator will be happy to consider any amendments that improve the bill. It would be helpful if they had come prior to today so that we as the Judiciary Committee could have looked at them. If there are any significant changes, can we ask that the bill be brought back if they are? Fair enough.
Of course.
I have every confidence that you will give due consideration and work with the courts to fashion this to meet your requirements, at the same time trying to address the concerns many of us have, and I know I do, with the fact that the courts are right now strapped as it is, that we want, particularly in these situations, the courts to do the best work possible. These are our children that we're talking about, but recognizing that there are some limitations that are fiscally imposed, trying to do the best that we can under the circumstances. Could you identify a couple of the changes that you are going to be asking for? And I'd like the Judicial Council to indicate whether those are similar to the concerns that you've expressed. I'd like to see if we're all kind of basically in the same page here. So,
well, I think the main issue that I've seen so far as having any concerns from any of the stakeholders is the issue with respect to an adult parent now who has a child who previously was a teen parent and was in the system as a dependent and lost their child through termination of reunification services or their inability to reunite with the child. If you have a 25-year-old person now who has a child, but they have a history when they were 15, 16 years old of losing a child, according to the way that the amendment is that's being proposed, is that they should the court must find by clear and convincing evidence that it would be in the best interest of the child to recognize these exceptions so that adult parent would not be, saddled with that history. And so I think out of a matter of fairness and equity, that since those parents, those teen parents, when they went through the system and had the review hearings, the court wasn't really specifically addressing those limitations then. So I think that now with this bill, if we get this passed, I think that they will have to identify those limitations, those barriers. So I think we're happy to work with the author and this is the Judicial Council? Yes. The folks from the Judicial Council. And I think Flexcom also from the State Bar had an issue, very similar issue, that we're willing to work with.
Is that similar to the issue that you're about to articulate in a letter?
The concerns I had raised to me by a lot of our family court judges and dependency court judges had more to do with discretion and limiting it to these specific factors. As I said, we're in the process of formulating amendments that we'll be offering, that the court may offer reunification services if there's evidence that the minor parent will benefit from such services and the child will as well.
I sit on the Judicial Council, but I'm not very happy that it's taken this long to get responses from the Judicial Council. I know that we've asked for them previously, and I know that Senator Liu is very responsive to reasonable concerns, but frankly, this bill isn't cooked. Senator Liu, do you have any thoughts or suggestions at this point?
Well, it's, it is last minute.
Yes, it is.
I'm always happy to listen. I think this goes to, it goes to fiscal appropriations. There is a time to work out some amendments, and happy to do so.
All right, given that the time is of the essence, and if you would please relate back to your shop that this is not very impressive to be this late in coming in. We will, given the fact it is going to appropriations, I know the senator will agree to keep working on this bill, but this isn't good.
And if there's substantive, we'll come back to you.
Fair enough, fair enough. Okay, Senator Wojtkowski.
Am I on?
Yes.
I'm concerned you've narrowed the bill from the 16 exceptions to the 4 exceptions, and one of the exceptions that is not being included, at least from a report on page 4 that we have, is that there's no reunification because of physical or sexual abuse caused by the parent or another person because of the parent's negligence. Now, it seems to me that if you're a minor parent, you're at least, the chances of you being negligent and having some situation, admittedly bad, that occurred to this child would alter once you became, or might improve when you became an adult. It wasn't you that had done the physical abuse or you that did the sexual abuse. You were just negligent as a parent. So I'm worried that some of the goals that you're getting may be missed if you don't open it up to all of the 16 exceptions. So while there may be some unknown objections by the Judicial Council, I sort of am looking at all of them and giving it back to the discretion of the judges to determine when they balance the interests of the children and the family interests, that it may, reunification may be in order. I guess that's, am I missing something?
Well, we are working out all of the questions that you have and other folks have proposed, and we'll continue to do so as we move forward. I mean, we're not hiding anything here. We're just trying to make it the best possible way to address the needs of these families.
Right, and I guess my point is, or my concern is that when it's mere negligence by this minor parent, that we would really want to, in the best interest of the family, take another look at that and see if reunification would be, I would hate to see them not qualified
I understand.
Well, if I'm not mistaken, the court still does have the discretion.
The court has the discretion now to evaluate whether or not it would be in the best interest of the child to order services for a parent. But we're trying to make certain exceptions because of their minority when these things happened. You raise a good point, Senator, as far as the negligent aspect of something happening sexually or physically to a child. So that's something also that we should maybe consider further.
All right. Any other questions? With the understanding if there's anything substantive, it will come back, but there will be additional amendments taken as the bill moves forward, and the Judicial Council will get that letter out quickly and get on this one. The Chair would entertain a motion. Moved by Senator Wachowski. Any further debate or discussion? All right, Madam Secretary.
The motion is due pass to Senate Appropriations Committee. Jackson?
Aye.
Jackson, aye. Vidak? Aye. Vidak, aye. Anderson? Aye. Anderson, aye. Hertzberg? Aye. Hertzberg, aye. Leno? Monning? Aye. Monning, aye. Wachowski? Aye. Wachowski, aye.
All right, that bill has 6 votes. We'll leave it on call for the absent member, and we look forward to seeing this bill move forward.
Thank you very much.
Thank you very much.
Thank you. All right. Thanks very much. Okay, Mr. Vice Chair, would you like to take the gavel? I've got a couple bills that I need to present.